shall be observed and shall govern the proceeding. Hearsay is admissible, but only to support other competent, substantial evidence. Other evidence must be presented. Are there any questions? Any decision made today can be appealed by sending a notice of appeal to the Circuit Court within 30 days of the execution of the orders per Florida State Statute 162.11. Can we have roll call, please?
Kathleen Brown.
Here.
Clifford Warren.
Here.
Dan Coffer.
Here.
Al Shemansky.
Here.
Keith McWilliams.
Here.
Aaron Denny's.
Here.
Does any member of the board have any ex parte communications to disclose? For the record, there are none. And has each member had a chance to approve the minutes of the November 20th, 2025 meeting?
Yes.
And if so, can I have a motion to approve?
So move. Second.
And can we have the swearing in of any city staff, any respondents, and any witnesses that may testify before us today? Please stand.
Please stand and raise your right hand. In the matter to which you are about to give testimony, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth? The witnesses have been sworn in.
Okay, first case, please.
First case is CCB-0488-2025, 205 Quay Assisi.
Good afternoon. So this case, CCB 04882025 for 205 Quay Assisi, was before the board on November 20th, 2025, and found Randall Todd Sr. and Suzette S. Jones and/or entity in violation of Section 26171A permit required, and gave until 1 p.m. December 8th, 2025 to bring the property into full compliance. If the board found that the violation was not corrected by this time, the board would discuss a fine to be imposed. The board's order was mailed, certified mail to the property owner, and was signed for and accepted on November 26, 2025. The board order was posted on the property on November 26, 2025. I've been in contact with Mr. Jones. He had called me December 2nd and told me that he had discussed this matter with his contractor, and the contractor told him that he would not need a variance, so he was not aware that a variance would be required based on the contractor's information. He said that if he had known, he'd have been here at the meeting. I sent an email to the planning department asking about the variance process and application. The planning department responded that they needed a pre-application meeting, and they did set one up and schedule it for the 10th, December 10th, 2025. And we received an email from the planning department stating that Mr. Jones had applied for the after-the-fact boat lift variance, and meeting before the Planning and Zoning Board is not scheduled until February 2nd of 2026. Therefore, it is staff's recommendation that the board continue the case until the February 20th Code Compliance Board hearing, so that he has time to go before the Planning and Zoning Board to see what they decide to do from there with the variance.
Okay. Is there anybody here that would like to speak on this case? Is there? And for the record, can you state your name into the microphone, please, so we can hear?
Great. Hi, how are you doing?
Good.
So I guess my first thing is I would just apologize to the group in here. I'm not into wasting a lot of valuable time, and I know you guys have a lot of valuable. Pardon me?
Give me your name and address for the record.
Well, my name is Randall Todd Jones, and my address is 205 Quay Assisi, New Smyrna Beach. That's my secondary residence. I also have a residence, permanent residence in Lakeland, Florida. So I'm only here probably 2 months out of the year in total throughout the year. Again, I apologize. I was given information that I would not need a permit to apply the second lift that I have on my dock. Obviously, that was incorrect information. Once I was notified of that and received a second code violation, I started doing all the due diligence necessary. I have gone down the path of trying to follow afterwards, unfortunately, all the information that is necessary, even meeting with the pre-meeting group that I guess does policy of what I'll need for the 7 people that I'll do the meeting on the first Monday of February. So I'm just requesting that we allow that to continue to happen to see if the 7 group does approve the variance or not approve the variance, and I'm hoping that the committee here will approve that.
Any questions from any of the board members? No. Can we have a motion?
I move we accept the recommendation to push it beyond the PNC meeting.
To the February, our next board meeting?
Yes.
I'll second that motion.
Kathleen Brown? Clifford Warren?
Aye.
Dan Coffer?
Aye.
Al Shemansky?
Aye.
Keith McWilliams?
Aye.
Aaron Denny's.
Aye.
Thank you, sir.
I did not. Okay. Thank you for your time. Sorry to bother your time. Thank you guys
Thank
for
you.
your time. Thank you.
Thank you.
See you guys the first week of February.
Next case, please.
Next case is CCB-0540-2025, 387 Otter Boulevard.
Afternoon, the case number is CCB 0540-2025. This property is 387 Otter Boulevard, zoned R1, single-family residential. Violation cited was 26-171, permits required. On October the 6th, 2025, Code Compliance received a complaint regarding a fence installed without a permit. I observed that the fencing had been installed on the front of the property and checked the permit system, found no permit had been applied for. Additionally, there was an expired permit for plumbing that was in the system. Therefore, the property was found to be in violation of Section 26-171. On October the 16th, 2025, a notice of violation was posted on the property with an initial compliance date of January 9th, 2026. A copy was also mailed certified mail to the property owner and was returned. Due to an error on the notice of hearing having the wrong date, a revised notice of hearing was posted on the property on December the 31st, 2025, and was sent certified mail to the property owner and is working through the system, with the corrected hearing date of today being January the 15th, 2026. On January 9th, 2026, a follow-up inspection showed a completed permit for the fencing. However, no action had been taken for the expired permit PLMR-00022-2023, which is still shown as expired. In staff's recommendation, the board defined Jonathan Porter Trust and Jonathan Porter Irrevocable Trust 10/22/2020 and/or entity in violation of Code Section 26-171 and give until January the 13th to bring the property. Excuse me. That's a correction. I'd like to correct that. It should actually be February the 13th. My mistake on that. February the 13th, 2023, bring the property into full compliance. If the owner does not come into compliance, it's staff's recommendation to impose a fine of $50 per day for violation of Section 26-171 until the property is brought into full compliance. Fine not to exceed $10,000 until the property is brought in full compliance.
Is there anybody in the audience that would like to speak on this case? Please come forward. And will you say your name for the record, please?
Yes, I'm Jonathan Porter. I live at 387 Otter Boulevard. We paid the amount for the permit for the fencing, and we got the inspection passed on December 19th of 25. And the lady over there said that it was the gas company's responsibility to file the permit for the gas thing, the plumbing. Yes, yeah. I'll call them. We haven't remedied that yet, but the rest of it should be in order. So.
Okay.
The fence is no longer in violation. He does have a permit and everything's taken care of for the fence, which was initiated. But the violation of 26-171 is for any permit that's in the system. So an expired permit in the system that has something else going on, being the plumbing permit, is considered to be an invalid, which would be considered a violation of 26-171. In other words, all the permits for the property have to be all valid, not just the fence.
Okay.
I saw the confused look on some of your faces. I want to clarify, the fence, he is correct. The fence has been taken care of. It's just literally clearing up a permit from 2023 that was a plumbing permit. That's the only thing that needs to be done.
Okay. Any questions from the board?
Yeah, so that's not related to the fence at all?
No,
It's
it's
independent,
actually, again, that's
but-
2023. The fence was installed this past year,
But it's
so
funny, but it was actually to permit some gas work?
I'm sorry?
It was to permit some gas
Some
work?
gas work, yeah, there was a tankless water heater installed, and I assumed
The contractor was
the
going to pull the
contractors
permit?
would have filed the permit, but apparently not. So I have to contact them, I guess.
Okay.
And we think that pushing this to the next meeting, or pushing for the date you had mentioned is enough time to have it all completed?
it appears by what he just stated, it's already been completed. It was completed back in 2023 or something like that. And therefore, I'm sure it just needs an inspection or to be finalized in the permitting system. It's literally probably clerical, more so than any kind of work that
So
would
it's
be
plenty
done.
of
So
time,
I think moving this to the next hearing date would be a good date for having compliance.
Any other questions?
Yeah, just one question. If you looked into the system, did you see any final inspection on that permit?
We just get the status of the permit.
Okay.
It doesn't break it down too in-depth. I mean, we can look and see there is no finalization done, otherwise it would have closed out the permit.
Can we get a motion?
I so move that we accept the recommendation.
Do we have a second?
Aye, sir.
Kathleen Brown. Clifford Warren.
Aye.
Dan Coffer.
Aye.
Al Shemansky.
Aye.
Keith McWilliams.
Aye.
Aaron Denny's.
Aye.
Okay, thank you, sir.
Okay, thank you.
Next case, please.
The next case is CCB-042-2025, 208 DeSoto Drive.
Hello, this is case CB-0642-2025. This is the first hearing for this property, 208 DeSoto Drive. The owner is Judy O'Malley. This property is zoned R2, single-family residential, and the violation cited is International Property Maintenance Code 302.8 for inoperative motor vehicles. In the original violation, IMPC 304.03, premises identification, which has been taken care of. LDR 802.02, storage on residential lots. This is concerning unregistered vehicles and trailers. LDR 802.05, RV storage. LDR 802.07B, trailer storage. NSB code 26171A, permits required concerning a fence. And NSB code 26172 that allows for the additional fees for the fence that was unpermitted. NSB 26914.8 for landscaping. 26914.9 for any trash and debris. It's concerning any kind of items laying around the yard. And 26914.13, which is outdoor storage, any items being stored on the driveway or the front yard, they should be removed. On December 10th, 2025, Code Compliance received a complaint regarding an overgrown property with an RV backed up to the front door and appears to have abandoned vehicles and a trailer in the front yard, several trailers, a couple of trailers. On December 10th, 2025, an inspection was conducted and the property was found to be in violation of the previous stated violations. On December 15th, 2025, a notice of violation was posted on the property with initial compliance date of December 30th, 2025. A copy was also certified mailed to the property owner, and a delivery attempt was made on December 17th and also December 22nd, 2025. And the U.S. Postal Service website states that a notice of attempted delivery was left, but the mail is undelivered. And on January 6th, a follow-up inspection showed little change in the property. However, the premises identification, some numbers, either I missed them or they were installed, but it does have numbers on the house. So that took care of International Property Maintenance Code of 304.03. So that was completed. I knocked on the door. I met with Mr. Ted Brown, who stated he was the owner's husband. He stated that the owner has some health issues and that he's aware of the current violation. He stated he wants to work on gaining compliance, and we discussed the various violations. I advised him that we would try to work with him, Code Compliance would try to work with him on allowing some extra time, perhaps skipping the February hearing and moving it to March, considering the number of violations that he had, but he needs to start making some significant progress as this property has had numerous complaints. We've had a lot of complaints on this particular property. So I did another site visit yesterday and today, and there's not a whole lot of other progress made on the property. And I asked Mr. Brown to come, and he is here today. But with all this being said, it's my recommendation for the board to find Judy O'Malley and or entity in violation of International Property Maintenance Code 302.8, LDR 802.02, LDR 802.05, LDR 802.07B, NSB Code 26171A, NSB Code 26172, NSB Code 26914, subsection 8, 9, and 13, and give until March 12th to bring this property into full compliance. And if the owner does not come into compliance at the March 19th, 2026 hearing, it will be my recommendation to impose a fine of $25 for each violation per each day that the violation exists. And this is $225 a day if nothing's done. And to run until they're brought into compliance. But I'm going to also request that the Code Board grant the city permission to abate the violations at a date and time determined by the city. Once the violations are abated, the fine accrual will cease for the specific violation that we abate. A lien will be placed for collection of the fines that are accrued. The cost incurred from the abatement will not be eligible for a lien reduction, and the fines are not to exceed $10,000. So basically, what we're asking to do is find the property until the city can abate it. If he doesn't do anything to fix it, then we'll have the vehicles towed and the property cleaned up from the front. And Mr. Brown did say that he would work on these violations, so I can let him.
Okay. My first question would be, at what date does the 225 start, though?
That would start at the March 19th hearing. I'll just ask you to impose it starting back to March 12th, because that's the when I'm asking for the,
To be in compliance?
yes, sir, to be in compliance.
Okay. Would anybody like to speak on this matter from the audience, sir? You have to come up and please state your name for the record.
My name is Theodore Brown, and I agree with what he's saying. And I mean, I don't have a defense. Look, I will get it taken care of.
Any questions from the board?
No.
Okay, thank you. Do we have a motion then?
I'd like to make motion to accept the officer's recommendation for the fine to be opposed at the next, I think it was March 19th, you said?
Yes, sir. The March 19th is the hearing date.
Yeah.
The 12th is the compliance date.
Okay.
And I'm hoping that Mr. Brown can get, the things tagged, the items out from being stored in the street, and just have them stored correctly, and his vehicle's registered, and the items, like the property, cleaned up. If he makes significant progress, then at the March 19th hearing, we could possibly come back and work with him a little bit more. But if he doesn't do anything, then the city has to move forward with what we discussed.
I like this solution.
So you made the motion?
Yeah, I made the motion.
In a second? Was?
Second.
Kathleen Brown,
Aye.
Clifford Warren,
Aye.
Dan Koffer,
Aye.
Al Shemansky,
Aye.
Keith McWilliams,
Aye.
Aaron Denny's.
Aye.
Okay, the respondents are further ordered to contact the code inspector to verify the compliance with this order and to also be aware that the respondents have the right to appeal the order when it comes out in 30 days. Any violation of the same code by the respondents within 5 years from the date of this order shall be treated as a repeat violation of which a fine up to $500 per day may be imposed. Next case, please.
Next case is CCB-0810-2024, 305 Julia Street.
The address is 305 Julia Street, case number CCSM 0810-2024. This property is zoned MU Mixed Use Central Business District. Violation cited IPMC 304 stairways, LDR 504.02, MU zoning district regulations. Section 26-171 permits required. Section 74-146 local business tax imposed. On November the 15th, 2024, I conducted a BTR inspection for the property, observing unsafe access to the second floor offices. The fire marshal's office advised that they suspected fire violations based upon the type of structure and usage, and therefore they were unable to pass the inspection. Excuse me. The entrance involved a steep staircase on the rear of the structure with uneven steps, distance, and height. The handrails and staircase were weak, and motion of rails and stairways requiring upgraded support. You could literally grab the handrail and give the entire thing a shake. The interior of the structure had been modified, remodeled without permits for offices, and the fire marshal and chief building official determined that a change of occupancy certificate was required. Business D2 Paving and Site Work LLC is located on this property doing business without a issued BTR. The property was found to be in violation of IPMC 304, LDR 504.02, Sections 26-171 and Section 74-146. On February 26, 2025, a notice of violation was posted on the property with an initial compliance date of April the 25th, 2025. A copy was also certified mailed to the property owner and was signed for and accepted on February the 27th, 2025. On May 12th, 2025, a check of the permit system found no applications for any permits, change of use, or BTR following inspections, or any follow-up inspections. The case was scheduled for the magistrate hearing on May the 28th, 2025. However, due to a conflict, The magistrate was unable to hear the case, and the case was reassigned to the Code Board. On June 20th, 2025, a permit was issued for the demo and repair of the stairs only, but the permit expired on December the 17th, 2025, with no action taken other than the issuance of the permit. On December the 11th, 2025, a notice of hearing was mailed certified mail to the property owner and was signed for and accepted on December the 13th, 2025. On January the 6th, 2026, a check of the permit system found no permit applications for the remodel of the second story in the office areas nor change of use, and the staircase permit is still expired. It's staff's recommendation the Code Board to fine 305 NSB Investment LLC and/or entity in violation of IPMC 304 LDR 504.02 in sections 26-171 and 74-146 and give until February the 13th, 2026 to bring the property into full compliance. If the owner does not come into compliance, it's staff's recommendation to oppose a fine of $75 per day per violation, except for 74-146 with no fine, only finding in non-compliance until the property is brought into full compliance, maximum fine not to exceed $25,000. The reason for that non-compliance and no fine on the BTR would be they can't obtain a BTR because there's things standing in the way of us being able to conduct the inspection, such as the staircase and the permits and everything. So obviously they're conducting business as a business in the city without a BTR. So that's the reason for the non-compliance. But I don't feel that a fine would be realistic in that aspect because there are other things that have to come first before they would even be able to have that BTR.
Anybody in the audience that would like to speak on this case? For the record, there are none. Any questions from the board? Any motions?
I move that we accept the recommendation.
Do I have a second?
Second.
Kathleen Brown,
Aye.
Clifford Warren,
Aye.
Dan Coffer,
Aye.
Al Szymanski,
Aye.
Keith McWilliams,
Aye.
Aaron Denny's.
Aye.
The respondents are further ordered to contact the code inspector to verify compliance with this order and to also be aware that the respondents have the right to appeal the order when it comes out within 30 days. Any violation of the same code by the respondents within 5 years from the date of this order shall be treated as a repeat violation of which a fine up to $500 per day may be imposed. So from here, any other questions from the board? No. Any comments? Then I'll adjourn the meeting. Thank you.